Sure. Well, shall we kick off then? To those on the line, welcome and thank you for joining us for this session, When Friends Become Foes, Arbitrating Shareholder Disputes and Minority Shareholder Protection. The session is recorded and registered for CPD with the Hong Kong Law Society. For CPD points, please make sure you're dialing in from your computer and that you stay for the full session. We'd welcome questions at any time. They can be submitted through the Zoom Q&A function, and we've allotted some time at the end to address as many of these as we can. By way of brief introduction, my name is Denise Fung. I'm a partner at Linklaters Dispute Resolution Team. I'm joined in the room by one of my partners, Justin Tang, and it's a real pleasure to be joined on the line by Victor Joffe QC and Junfei Ng QC. Victor has a formidable reputation as one of the most experienced and respected practitioners at the Hong Kong Bar, and as the author of the leading publication, Minority Shareholders, Law, Practice and Procedure. We're grateful to also have Junfei with us today. He's acted as counsel in over 350 cases and in over 30 cases as arbitrator, giving him multiple perspectives from which to draw on. He has significant experience representing Chinese corporates, and reflecting the geographical breadth of his experience, has a dual Hong Kong and London-based practice. We chose this topic today because of the steady rise we've seen in shareholder disputes across a wide variety of industries, often driven by corporate reorganizations, uncertainty, macroeconomic volatility. Arbitration of shareholder disputes poses some unique considerations and challenges, and I'm looking forward to discussing these today with Victor, Junfei, and Justin. In any arbitration, one of the earliest questions will be when a dispute arises is whether it falls within the arbitration clause. And the first topic I thought it would be interesting to explore is the scope of matters referable to arbitration and the interaction with other bases of claim. So Junfei, perhaps we could start with you, maybe giving us some examples of common disputes you've seen arbitrated under shareholder agreements.
Absolutely. Well, first off, a very good morning, everyone, to all of you who are attending this session, in which we have a very interesting discussion lined up for you ahead. And thank you, Denise, for the very generous and kind introduction. What I want to do, Denise, is start off by giving you 3 examples of matters which are commonly referred to arbitration arising out of a shareholders' agreement, and then to set out the general principle underpinning the jurisdiction of the arbitral tribunal in respect of these types of disputes, as well as more generally. So in answer to the question which you posed, Denise, in my experience, certainly of late, both as well as counsel, as well as an arbitrator, the common disputes, or some of the common disputes falling within a SHA, a shareholders agreement arbitration clause, are threefold. The first are disputes relating to the level of earn-out consideration, which is to be paid to the shareholder whose shares or part thereof were sold to the acquiring party. So typically what happens is in some shareholder agreements, or to be precise, some share sale and purchase agreements, which then lead to shareholders agreements being entered into between the selling shareholder and the purchasing shareholder. There are typically 2 levels of consideration for the price pursuant to which the shares are sold. The first is a, call it what you like, a base or an initial consideration, which sets a floor price or a minimum price pursuant to which the shares are conveyed from the seller to the purchaser. However, the bit which generates the most controversy and disputes is the second tier of consideration, which is the earn-out consideration. And typically, what this is contingent on, although of course there are as many different earn-out consideration clauses out there as there are share sale and purchase agreements and as there are shareholders agreements. But the nub of it all is that the earn-out consideration is typically payable by the purchasing shareholder, the acquirer of the shares, to the selling shareholder after a fixed period of time has passed following completion of the share sale and purchase, say, for example, 3 years, although it could vary depending on the subject matter of the share sale concerned. And the level of the earnout consideration is usually staggered by reference to, typically, the financial performance of the company whose shares are being sold. So, for example, where after 3 years have passed, the EBITDA of the company is X, then the amount of earnout consideration that will be paid would be a particular level. If it is a multiple of X, then obviously a high level of earnout consideration will be paid, so on and so forth. And if it falls below X, then it might be that a reduced or possibly no earnout consideration will be paid. As you might imagine, this is precisely the sort of area that is fertile and ripe for disputes, particularly in circumstances where such disputes, if they arise, usually arise after some time has passed from completion of the share sale and purchase agreement has been concluded, and perhaps whatever goodwill that there might have been preceding the entry into of the share sale and purchase agreement and the shareholders agreement may have dissipated or perhaps diminished over a period of time. So that is of late the most commonly encountered dispute arising out of a shareholders agreement. The second type of dispute is one which will no doubt be familiar to many of those attending in the audience, and it relates to the exercise of put or call options, and those need no further introduction. And the third most common dispute relates to the exercise of rights of first refusal, or for short, ROFR clauses. Those two are, the second and third categories are also likewise types of disputes which certainly of late have been commonly encountered in relation to shareholders' agreements. Now, in terms of the general principle of it all, perhaps I should add for good measure, there is a fourth, and this one is of a slightly different genre before I go on to the general principle, and that's claims for misrepresentation. So the gravamen of the allegation that is typically being brought is that where misrepresentation is alleged, the acquiring shareholder, it might be said, alleges that the selling shareholder had made certain false statements, in other words, misrepresentations, which materially induced the purchasing shareholder in either purchasing the shares outright or purchasing at a particular level of consideration. And I call this of a different genre because these are claims which, strictly speaking, are not anchored in the express language of the terms of the shareholders' agreements themselves or in the share sale and purchase agreement. Nevertheless, the common theme which underpins each one of these four commonly encountered disputes and other types of disputes arising out of shareholders' agreement is that they are by and large, so long as they are disputes between the contracting parties to the shareholders' agreement and typically to the ancillary share sale and purchase agreement, are referable to arbitration. And the reason for this, and here I go on to the general principle, is so long as is always the case as far as I am concerned, the arbitration clause contained in the share sale and purchase agreement and the shareholders' agreement is drafted in typically broad terms. So, for example, you would say something like, any and all disputes arising out of, under, in relation to, or in connection with, or any combination of those phrases, shall be referred to arbitration. Then, pursuant to one of the leading cases in the common law world, which is a decision of the UK House of Lords in a very well-known decision called Fiona Trust and Prevalov, there is a presumption, albeit it's just a presumption, a rebuttable one, but nevertheless a strong presumption of one stop at adjudication. In other words, to the extent that there is any dispute which is connected to even those covering claims like misrepresentation, which are in connection to the shareholders' agreement themselves, then the presumption is that the parties to the shareholders' agreement and, of course, the share sale and purchase agreement acting as commercial and rational business people would have presumed that disputes arising out of those shareholders' agreements, even to the extent that they cover claims like misrepresentation for having materially induced the purchasing shareholder to enter into the shareholders' agreement at the terms which are agreed. And of course, it goes without saying, covering some of the other commonly encountered disputes of the type which I have just outlined, like earn-out disputes, put-call options, and ROFR, or right of first refusal clauses, are disputes which are squarely within the jurisdiction of the arbitral tribunal. Now, that of course gives rise to interesting disputes, which Denise, I know we'll come on to cover on later on in this webinar, about what happens when there are third parties to the arbitration agreement, which are also caught up or bound up in some of these disputes. But certainly, in terms of the general principle, is that there is a very broad, encompassing approach to the scope of arbitration clauses in relation to disputes which are said to be connected to a shareholders' agreement.
Thanks, Zhengfei. Just listening to you kind of talk about these common disputes and common themes, one thing that struck me is that another common thread that you might draw from the examples that you've given is that they seem to all relate back to the commercial terms or the commercial aspects of the shareholder relationship. I might contrast this with what we might refer to as corporate control or governance aspects, which are distinctive of shareholder and joint venture relationships. And when disputes arise out of corporate control or governance mechanisms, I think there is a greater possibility that these fall outside the scope of what is arbitral. And so maybe, Justin, you could talk a bit more about this and hybrid claims.
Sure, thank you, Denise. Well, as Zhengfei said just a moment ago, there are the types of shareholder disputes which we commonly see when we advise the clients that fall squarely within the scope of the arbitration agreement, contain a shareholders agreement or the share purchase agreement. So in those circumstances, then a jurisdictional challenge would be quite unlikely because of the clear connection between the disputes and what's envisaged between the parties as falling within the scope of the arbitration agreement. But very often, even when there are allegations of specific breaches of provisions of the agreement in earn-out disputes or in disputes arising in relation to ROFR or put options, there could potentially also be sort of potential and or scope for a case of unfair prejudice to be mounted. So, for example, I was personally involved in a case where we are acting for the respondent to an arbitration. So the claimant, the 50% shareholder, then put in a notice of arbitration in relation to arbitration at HIC. So in the notice of arbitration, they introduced a kitchen sink of allegations, so alleging basically everything that you can consider that could conceivably go wrong in sort of the type of shareholders relationships. For example, freezing out of the directors appointed by the claimant shareholder, and also the passing of resolutions by the directors nominated by our client without the unanimous consent of the board, and thereby in breach of the reserve matters provisions. So in those situations, then you would have these specific breaches of the provisions of the SHA, and in parallel, you would also then claim that those breaches form part of the wider conduct on the part of the other shareholder. They want to seek relief. And the reason for introducing a case of unfair prejudice is obvious, because then in that case, then you can actually then potentially convince the tribunal to grant relief of much wider scope. So if you want to exit from investment, then what you would want to seek in terms of relief would be a buyout order and a price to be determined by the tribunal. What if you don't want a buyout order, you want to stay involved in the management and operation of the company, then you could potentially then seek relief that can be tailored to specifically address and rectify the unfair prejudice in question. So that's really the upside of introducing a case of unfair prejudice. But the point that I would like to flag is the potential that in cases where allegations of unfair prejudice are alleged or concerned, then jurisdiction could be an issue, and that's often I think results in a big debate between the parties in the case that I just alluded to, for example, and that was a big debate around the jurisdictions of the tribunal to determine specific allegations around breaches of the Articles of Association or allegations around directors' breaches of fiduciary duties, which could arguably be matters for the law, the company's law of the place of incorporation of the JV entity or the target company question, and therefore could potentially fall outside the scope of the arbitration agreement. So I just wanted to say that, well, on the one hand, there are positives, upsides to introducing a case on fair prejudice, but at the same time, that would also highlight the potential for jurisdictional objections to be taken, depending on the precise wording of the arbitration agreement contained in the shareholders agreement.
Thanks, Justin. And I suppose to your point about the kind of much wider scope of relief available, when a dispute does go to who is in control of a company or how that decision-making power is shared, one of the kind of more dramatic remedies that you might be considering is winding up the company altogether. In this respect, perhaps maybe going to Victor, what are some of the things to bear in mind when seeking a winding up?
Well, good morning, everybody. Justin, of course, has emphasised the width of the unfair prejudice remedy, and it's certainly the case that winding up in recent years has tended to be eclipsed by unfair prejudice. But it still has a role to play. There may be legal reasons. You might want investigations using a liquidator's powers. There may be practical reasons. For example, respondents don't actually have the means to purchase the claimant's shares, and the company has available assets to distribute amongst shareholders. But when you're talking about just and equitable winding up, it is actually a very wide phrase. And the problem there is the potential divergence between matters which are covered by a shareholders agreement and its arbitration clause and matters which aren't. Now, when you're talking about things which are unlikely to be covered, which are nonetheless just and equitable, you're thinking about things like shareholders losing confidence in the director's ability to manage the company's affairs because of lack of probity, lack of fair conduct, that sort of thing. Or you're talking about the inability of the company to function in accordance with its intended purpose, that sort of thing will unlikely be arbitrable because it's outside the shareholders agreement. And so if there's an application for a stay of arbitration, it's not likely to succeed. Now, if you look on the other side at things which are likely to fall within the shareholders agreement, the obvious point to make there is that the power to wind up companies, to make a just and equitable winding up order, is one which is conferred by statute on the court. And it's settled that a company's articles can't restrict a shareholder's right to petition for just and equitable winding up. So assuming that you've got a broad arbitration provision in a shareholder's agreement, the question is what effect that sort of provision has on the right to petition for just and equitable winding up. And in particular, can a shareholder exercise his statutory right to petition for just and equitable winding up, notwithstanding the existence of that sort of broad arbitration agreement? Now, starting point is that case law in several jurisdictions, including Hong Kong and England, has made it clear that the arbitration agreement cannot confer on an arbitrator the power to making a winding up order. Only the court can do that. But that's not the end of the matter, because the case law also makes it clear, firstly, that the arbitration agreement operates as an agreement not to present a winding up petition unless and until the underlying dispute has been determined in the arbitration. And secondly, they make clear that the arbitrator can decide, firstly, whether the underlying dispute has been made out as a matter of fact, and secondly, if so, whether it's appropriate for a winding up order to be made or whether there's some lesser remedy which is appropriate. And thirdly, they say that if the arbitrator does decide winding up proceedings are justified, then the shareholder can present a petition. And of course, if the underlying facts have been determined in the arbitration, they can't then be reopened between the same parties in the petition proceedings. So, drawing all those threads together, although the ambit of the arbitration agreement does not embrace the ability of the arbitrator to order winding up, the effect of arbitration provisions in shareholders' agreements is to enable the court to grant a stay of a just and equitable winding up petition if it is brought prior to the determination of the underlying dispute in the arbitration. Of course, if the arbitrators decide the dispute and decide that winding up is appropriate, then the stay can be lifted. But if there's no prior petition and the parties simply proceed straight to arbitration, then the arbitrators can give their determination. If they determine that just and equitable petition is appropriate, then petition can be presented. Now, the problem with all of that is this, that you've got some things which are within the arbitrator's domain and some things which are not. So inevitably, if you are looking at seeking a winding up, you're dealing with bifurcated proceedings. So you're going to have the arbitration first and then the petition. So it's a bit like having bifurcated court proceedings where you are having liability determined by the arbitrator, but relief determined by the court. But unfortunately, in the current state of the law, there isn't any alternative to that bifurcation in proceedings. I go over to you, Denise.
Thank you, Victor. So I think just to add to what has been said by Victor, I just wanted to sort of mention a case that I was handling sort of last year, where we were helping a client put together the notice of arbitration. So as is sort of the usual practice, then we put in both a claim for remedy for unfair prejudice and also a claim for winding up on just and equitable ground as an alternative form of relief. And then we succeeded in terms of getting the underlying allegations substantiated before the tribunal. And then we were asked this question by the tribunal as to, so now you've substantiated your case. So which one do you want? You want a buyout order on the basis of the unfair prejudice jurisdiction of the tribunal, or you want actually a declaration to the effect that there are grounds which would support and just and equitable winding up of the JV entity. And then in that circumstance, I think the client asked us this really important question, which is, what do you think about enforceability of a wind-up order that might be granted by the Hong Kong court on the back of that tribunal's decision in China? Because notwithstanding that the underlying JV entity is a Hong Kong incorporated entity, it has substantial operation in China, and most of its assets are actually in China. So unless you, Justin, is telling us that we were standing a very good chance of being to enforce the Hong Kong wind-up order as against the assets in China, although belonging to the Hong Kong JV entity, then I think it would make more sense or commercial sense for us to go with a remedy for a buyout of our investment in relation to the JV. And so the reason why I mentioned that is because I think clearly the client's concern at the time was the enforceability of the Hong Kong wind-up order in China, and that concern obviously is still legitimate and understandable at the time, has to an extent been addressed with the introduction this year of the new arrangement between Hong Kong and the PRC, which has established a legal basis for the PRC courts to give not just recognition but also assistance to Hong Kong court office holders in terms of recognizing the appointment and helping them in terms of exercising their powers in the PRCs. So it's still in early stages because it's only been months since the introduction of the arrangement, but we're already seeing a lot of approaches from liquidators in Hong Kong in relation to the making of such applications to the courts in the PRC. Currently still in 3 pilot cities, Shanghai, Xiamen, and Shenzhen, but it's definitely a welcome development in the right direction.
Thanks, Justin. Maybe now moving on beyond the direct relationship between shareholders. As we have already alluded to, in many cases, shareholders are not the only relevant actors in a shareholder dispute. You'll have the involvement of directors, you'll have potential influence of a parent company. But because arbitration is premised upon the consent of the parties to that process, there seems to be an inherent limitation on the scope or the ambit of an award or an order. Maybe Victor, I could come to you for your thoughts on this first.
Yes, well, I'm going to start by talking about the persons against whom one might want to seek remedies, or indeed, certainly in court proceedings, one can seek remedies in an unfair prejudice case. Now, as you will know, where you're dealing with a petition, you would normally make shareholders in the company parties to the petition. And so that gives the court the ability to consider whether relief should be granted against those sorts of parties. And we are talking about the most common form of relief which is sought, which is the share purchase order. Then often the order will be made against the other shareholder or shareholders, sometimes against the company. But there are a number of categories of persons against whom orders could also be made. And in particular, one's thinking about a former member, somebody who's already divested themselves of their shares, but who might have been a shareholder at the time of the unfairly prejudicial conduct. One's thinking about a non-shareholder director, again, might be responsible for the conduct. One's talking about third parties who in some way have improperly assisted in diversion of company funds or assets. And then more recently, the courts have developed a set of principles for dealing with what I like to call the puppet master category. And that is people who are sufficiently implicated in unfairly prejudicial conduct, or who benefited from conduct, or maybe even condoned it, but they didn't actually themselves carry out the unfairly prejudicial conduct. And one's looking at orders against those sort of people, even if they aren't or have never been shareholders or directors of the company. And one looks particularly at the sort of case where the shares are held through a nominee, or where there's a nominee director, or where you might have a string of nominees in a complicated corporate structure. Now, when you're looking at those sort of parties, there are really two principal limitations on the ability of an order to be granted against those persons. The first one, the more important one, is the question of whether the relevant respondent is in fact responsible for the unfairly prejudicial conduct to the extent that relief can and should be granted against him. Now, in those cases, it's necessary both to allege and also to prove that the relevant respondent was either directly or more likely indirectly responsible for the unfairly prejudicial conduct. In other words, the allegations which are actually made against the respondent have to be sufficient to show that he was directly or indirectly responsible for the unfair prejudice. And the test which is normally adopted in terms of attribution of unfairly prejudicial conduct is whether the respondent is so connected with the unfairly prejudicial conduct that it would be just to grant a remedy against him in relation to that conduct. And so really being connected isn't enough. Something more than mere connection is necessary. And obviously that depends very much on the circumstances of the individual case. But very often that question is considered by thinking about whether the subject company is merely a cipher or an alter ego for the respondent. And often key is whether the respondent has benefited himself or possibly through a company from that unfairly or prejudicial conduct. So it's not enough merely to allege that relief should be granted against respondent A on the basis that respondent B did something with the support of respondent A. It's not enough to show that, well, if respondent A didn't know what respondent B was doing, he wouldn't have stopped it anyway, because responsibility for unfairly prejudicial conduct arises from actual conduct on the part of the respondent or responsibility for another's unfairly prejudicial conduct. Hypothetical conduct isn't sufficient. I think that the trend, certainly of the cases in court, is to expand the category of persons against whom an order can be granted. So there's almost a long-reach jurisdiction developing in terms of respondents. But the problem is that many of those respondents are not necessarily immediately amenable under an arbitration clause. And I think that's where Joan Fay comes in, is it not?
Sure. Perhaps we can turn to Joan Fay then.
Absolutely. Well, just building on what Victor has very usefully articulated, which is to outline, obviously, the type of respondents against whom orders may be sought in the context of unfair prejudice proceedings. And just to circle back to something which I had foreshadowed earlier on when I was talking about the scope of the arbitration clause and its possible limitations vis-a-vis third parties to the arbitration clause itself. I know that Victor touched on the roles of directors in their various incarnations. And I just want to touch on a little bit more about that, because obviously there are directors in the de jure sense, in other words, in the legal formal sense, someone who has been formally appointed as director, but that in most common law jurisdictions, including Hong Kong and England, obviously, is simply one of different categories of people who are held to the responsibilities and standards of a director of a company, because, and this is what I would describe as hornbook law, is that directors may be of three kinds. The first are the one which I have already referred to, which are de jure directors, being directors who have been validly appointed to the office of director. The second is what are typically described as de facto directors, being persons who assume to act as directors without having been validly appointed or indeed been appointed at all. And the third are what we call as shadow directors, or perhaps as Victor referred to as the puppet masters, being persons in accordance with whose directions or instructions the directors of the company, or a majority of them, are accustomed to act. And these classes or types of directorship are recognized because the law requires that persons who act as directors and who thereby exercise the powers and discharge the functions of a director, whether validly appointed or not, must accept the responsibilities which are attached to the office. Now, by way of a subsidiary observation, in terms of the threefold classification of the types of persons who are or are to be regarded as directors, namely de jure directors, de facto directors, and shadow directors, can I just make this subsidiary observation that it is again well established as a matter of common law at the very least, that those who can be held to be directors are not just natural persons, but also extended to legal persons or corporate persons. Therefore, in circumstances where, for instance, taking the third of those, the threefold classification of directors, which I just set out, namely shadow directors, it could well be the case that the person by whose directions the directors or a majority of the directors of a company is accustomed to acting may well be perhaps be a parent company or an affiliated company or some other corporate entity, and therefore in those circumstances the corporate entity can likewise be held to be a director. And the source for this threefold classification of directorship and therefore the possible targets against whom sort of orders which Victor adverted to may be sought are, as far as English law is concerned, there is a very useful leading position of Mr. Justice Millett, as he then was, in a case called Rehydrodam Corby Limited, and of course more recently by the Hong Kong Court of First Instance in a case called Cyberworks and May R, which is a magnum opus in setting out very useful distillation of the principles pertaining to this area of the law, summarizing and distilling, as Mr. Justice Coleman did, the principles which are elucidated not just from Hong Kong case law, but also from the case law of other common law jurisdictions, including but not limited to England on this subject. And so just to supplement what Victor said is, in addition, obviously, to sort of orders you might want to seek against such third parties in the context of unfair prejudice procedures, there is also the possibility of actions which are brought against non-shareholder directors. And by directors, I mean obviously any one of those encompassing the threefold classification of directors in respect of acts or conducts which are detrimental either to the company of which he or it or she is a director, or detrimental to the shareholder himself, herself, or itself. And just to give you but some examples of the sort of conduct which would be regarded as detrimental conduct, is there could be directors passing resolutions that breach shareholder agreement provisions. There could be directors removing funds or diverting funds outside of the company to external sources. There could be directors entering into contracts on terms that are not in the best interests of the company, or perhaps the contracts themselves are disadvantageous to the company of which they are director. That may in turn cause harm to the shareholders. So what Victor focused on was the harm to the company and how that might be remedied. And in terms of, and of course to the shareholder itself, but as far as the shareholder is concerned, there is another form of harm in terms of economic loss which can be remedied not just in the context of unfair prejudice proceedings, but also in the context of claims potentially in tort against the non-shareholder director for any one of the or more types of wrongful conduct which I had adverted to just a few minutes earlier.
Thank you, Zhang Fei. Just to pick up on the theme that you were just describing as the root of the problem, which is that the actors who were involved or engaged in the unfairly prejudicial conduct could be more than just immediate shareholders to that are parties to the agreement to arbitrate, but it could also extend to directors, whether individual or corporate or affiliates of the shareholders, including the parents. So obviously there are solutions, such as the ones that you just described. So either we try and join those parties to arbitration, or alternatively we commence court proceedings, either to seek interim relief against them or more substantive relief against those non-shareholder actors. So what I would like to supplement what you have just said is we don't always have to wait until a dispute has arisen before adopting those solutions. So there is something we can do even at the time when the parties, the shareholders, are negotiating the terms of the shareholders agreement. So there are different ways of achieving that end. One option that we often see is we try to make the joint venture entity, the target company, that's the subject matter of the acquisition by the purchasing shareholder. as additional party to the shareholders agreement. So that's often done so that you have a direct course of action against the company. So in the situations that Zheng Fei has described just now about the passing of unauthorized resolutions by other shareholders or board in relation to the affairs of the company, then you can make sure that whatever relief that you might obtain from a tribunal is binding and enforceable as against the JV entity. Another possible option, just to deal with the point again Zheng Fei has alluded to, we can actually have the parent company of the immediate shareholders also added as parties to the share agreement. That's often done because we often see parent companies actually give an undertaking to the respective shareholders, guaranteeing the due performance of the obligations by their subsidiary shareholders to the underlying agreement. Another option, insofar as directors' liabilities are concerned, obviously it would not be practicable at the outset of the shareholders agreement to have the directors or officers join as a party to the agreement. But one way of addressing that issue or maximizing the ability of the shareholders to seek relief in case there is misbehavior on the part of the directors, maybe several years down the road, is to have the shareholders agreement specifically provide for a positive obligation on the part of the shareholders to procure that whoever they appoint as directors or officers of the company comply strictly with the terms of the underlying shareholders agreement or JV agreement. That way, if they misbehave, so apart from joining them, the directors as parties to arbitration or any court proceedings, then you will also have a direct course of action against the immediate shareholders in relation to the misbehavior on the part of the directors that they appointed. So those would be my observations in terms of the pre-dispute and also the post-dispute solutions to deal with this rather difficult issue, which often comes up in shareholder disputes.
I think there was one final topic that we wanted to cover, which we've also alluded to. I think Victor also mentioned bifurcation. That was in the context of the remedies that you might seek. Then in terms of the bifurcating between merits and quantum, that is something that we see both in arbitral proceedings and also in court proceedings. And one thing that is often a point of contention is when that shareholding is valued. And Victor, I believe you have significant experience in this area. Maybe you can lead the discussion on this.
Yeah, it's almost never the case that the parties agree on the valuation date, and the usual reason is because, as we all know, the value of the company can change drastically sometimes over time, sometimes due to external circumstances, for example, a pandemic, sometimes due to individual management success or failure. But ultimately, the choice of valuation date in an unfair prejudice case is within the discretion of the tribunal. And the overriding legal requirement is the date should be fair to best reflect the remedy required. Now, we have a long line of decided cases in Hong Kong and in England, which in effect say that the prima facie or default position is that an interest in a going concern should be valued as at the date of the purchase order. So if neither party puts forward an alternative, that will usually be the relevant date. But the cases do recognise that the parties might want to put forward an alternative. And of course, if the tribunal thinks that an alternative is fairer, it can order an alternative date. And essentially, there are three principal alternatives. The first is an early valuation date where the company has been deprived of its business. And the obvious example, I think, is one given by Zheng Fei before, which is where the company's controllers divert business or assets to themselves or to their own company and cause the subject company's value to decline. And in that sort of case, a claimant might well put forward the date of commencement of proceedings or possibly the date of the misconduct as the correct date. And that category could also include other situations where serious misconduct is the cause of the decline in the company's value. And again, Joan Fay gave us some examples of that before. Another one might be investing the company's assets in a reckless venture. Now, the second category, very much related to the first, it's where after commencement of proceedings, there's a general fall in the market. The theory here is that the claimant has been locked into this company by the unfairly prejudicial conduct of controllers when he should have been released earlier. And so he shouldn't have to bear the decline in the value of the company. And the third category is where the company has either been reconstructed or had its business changed very significantly, such as by becoming a new economic entity. And early valuation date there is intended to promote fairness between the parties, because on the one hand, the respondents might have invested very considerable time, money, efforts into the company and made substantial profits as a result. And so it wouldn't be fair to allow the claimant to share in them. On the other hand, those sort of changes might have adversely affected the value of the company. So there's no particular reason why the claimant should suffer losses. And so in those sort of circumstances, either the claimant or the respondent might have to ask for an early valuation date. Now, of course, that type of case requires consideration as to whether the company's fortunes have improved or declined, and if so, who or what is responsible for that state of affairs. And one of the phrases you see frequently in decided cases is sea change. Now, it's not a precise formulation. It's not, of course, a statutory formulation, but it does give you a fairly good idea of the sufficiently fundamental change to the company's affairs which you need in order to justify an early valuation date in those sort of cases. Now, those three categories, of course, are not closed. They're not exhaustive. They're only guidelines. And often other reasons lead to an early or possibly a later valuation date. A good example would be exclusion. If a claimant has been excluded from the business and that's the basis of unfair prejudice claim, then sometimes an early valuation date is given. In other cases, the claimant has just sat back and allowed the company to carry on. He's drawn profits by way of dividends. And in those sort of cases, perhaps a later valuation date is required. But having said all that, generally speaking, there are two points to make. Firstly, claimants aren't entitled to what's called a one-way bet. In other words, they're not entitled to just the valuation date which gives them the best possible exit. And indeed, if the claimant has delayed and the value of the company has increased, then he may find a later valuation date is selected. But the other point, and I think in many ways most important of all, is this. If the claimant, or indeed the respondent, wants an alternative to the order date, it's very important, firstly, that he what facts he relies on to justify alternative date. Second, that it's evident to back up the contention. It's not enough to be raised at either a hearing or experts and Faye's have experience. I mean, certainly in my experience, you've got either a hearing or an arbitration hearing where at the last minute says, well, or possibly even in closing submissions, that the evaluation date ought to be an earlier date for whatever reason. And that is simply not good enough. And of course, that does sometimes and very often leads to bifurcation in court and arbitration proceedings, because if you have a dispute as to the valuation date, then that needs to be resolved, and it's often unwise for a tribunal, court or arbitration to order exchanges of expert reports ahead of determining the valuation date, because there's no point in spending lots of money on experts and their valuation reports if the valuation date is not agreed.
Thanks, Victor. So it sounds like, at least from a cost and efficiency and case management perspective, sometimes there may be an argument for bifurcation and dealing with the merits first before you deal with valuation. Zhengfei, do you find that is the case for most of the cases that you have dealt with, or does it really depend?
Well, I'm going to do something which I typically eschew, whether in the context of a webinar or in the context of a meeting with clients who ask me for my views, and I'm going to hedge my bets, only because the question, Denise, which you asked me was what I typically or commonly encountered. And I would say that in about 50% of the cases in which I commonly encounter, actually, I would say about 60%. So maybe I'm not hedging my bets after all. In cases in which I commonly encounter, there is no order for bifurcation, whereas in perhaps the minority of cases, or just about minority of cases, about 40%, there is an order for bifurcation. The reason, however, for perhaps the slight preference, and my preference, if you ask me, all things remaining equal, of course, it really depends, as any good lawyer would say, on the facts and circumstances of each case. But if I were to express a general preference, and certainly that is reflected maybe in the 60-40 apportionment of my experience, is that more often than not, there is no order for bifurcation. Only because in the context of an arbitral process, unless there is a specific reason why there should be an order for bifurcation, perhaps because it would be efficiently, rapidly dispositive of the arbitration proceedings as a whole, in circumstances where there would be a substantial net savings, perhaps in time and costs, then otherwise it would simply be more efficient for all of the issues in the arbitration. I'm just focusing on arbitration proceedings alone, and I appreciate that the considerations may differ in terms of other types of legal proceedings, but just focusing on arbitration proceedings alone, it is not necessarily always the case that bifurcation would generate substantial efficiencies. Notice I place an emphasis on the word substantial efficiencies. And what do I mean by that is commonly there may be a reservoir of facts, evidence, etc., which is common to issues of liability and quantum, or issues which might otherwise be bifurcated and therefore dealt with separately. They may give rise to contested issues of fact for which findings have to be made by the tribunal. How these findings are then applied to the issues for determination, whether they are of liability or of quantum, can be of some significance, and it can be fairly nuanced depending on the issues which the tribunal is asked to grapple with. And more often than not, as is my experience, and again, it's difficult to overly generalize on this, is that where you are dealing with issues of quantum, it may well be the case that the additional issues which have to be grappled with so far as quantum is concerned are computation issues, if I can describe them as such, quantification of the damage that is to be awarded to the claimant or to the counterclaimant, as the case may be, and that typically only involves the production of competing expert reports on quantum and a joint experts memorandum, perhaps some expert report on foreign law if the governing law by reference to which the principles of quantification are to be determined is not a system of law which is familiar to the arbitration in the seat where the dispute is being resolved. And maybe, but just maybe, there may be a sliver or a pocket or a category of factual evidence that is unique only to quantum alone that has to be determined. But in the context of the arbitral process as a whole, that typically only adds maybe one two procedural milestones to the overall procedural timetable of the tribunal, such that it has to be seriously asked if there was bifurcation, bearing in mind that when you bifurcate, there is a period of time that has to elapse before a final award on liability or on a final award on the first group of issues is produced by the tribunal, before one then goes on, obviously, to the second phase of the proceedings, whether or not the overall timetable is necessarily one that generates substantial efficiencies, whether in terms of costs and time. And in a lot of the cases which I do, the answer to that question is typically no, although that does not, of course, exclude the prospect of an order for bifurcation in any event, and certainly not if, contrary to what I've just said by way of perhaps overgeneralization, there are circumstances where there would be a substantial savings in costs and time by bifurcating.
Thanks, Zhengfei. I have my eye on the time, and I know that I said we would leave as much time as we could for questions. So one final point I just wanted to make in the context of quantum, and Victor alluded to this, is the use of experts. And as Victor says, parties are very unlikely to be in agreement on the value of the shareholding in question. And so an expert will be needed to support the assertions that are being made about the value of the shareholding. And choosing an expert is not simply about finding someone who can perform those computations, those calculations to assign a value. The quality of the expert's evidence is going to have a direct relationship with how much the minority shareholder might recover if a buyout order is the relief that's sought. And so some of the things that can really make a difference, Zhengfei, you alluded to the first one that I wanted to raise, which is to start the search early and engage your expert early, because oftentimes the issues of liability and quantum will overlap. And so you may want to have your expert on board as early as when you're putting together your case theory. Besides this, just as a practical matter, finding the right expert can take time. And the earlier you start the search, the higher the chance you have of securing the right person for your case. You might also avoid the other side, engaging the expert you've identified as your first choice. Really, experts with the right credentials and experience are in short supply, and clearing conflicts we find sometimes can be a real hurdle. So secure your expert as early as you can. Also consider whether the sector expertise is going to be relevant. So depending on the facts of the case, some knowledge can be helpful or even essential. Tech, mining, and pharma are some examples where sector expertise or relevant degree can sometimes make the expert more credible, not only in front of the tribunal, but also with the client. In a similar vein, also think about local knowledge. Business landscape and practices can vary hugely, and sometimes having the expert that is aware of and appreciates the local context can be important. Beyond their credentials, also consider how well the expert explains his analysis and advice. So remembering that they'll be required to give evidence before a tribunal at the hearing, remember that you need to think about whether they're able to give the advice well, both in writing but also verbally. And although we often talk about engaging an accountant or a consultancy firm, at the hearing you're putting forward an individual. So it is really the quality and credibility of that individual that's going to be important. A lot of the questions that we often ask the individual are how many times they've been engaged as an expert. We also ask the separate question, well, how many times have you given evidence at a hearing? So the proverbial kind of settlement on the courthouse steps means that the number of times that an expert has appeared before a tribunal will always be lower than the number of times they've been engaged as an expert. So do think about whether they have experience of adversarial context and proceedings and how they're going to hold up under cross-examination. So that was a very kind of quick laundry list. I'm sure our panelists will have more to add to that list, but we have 1 minute, and I'm going to go to some questions. Perhaps, Zhengfei, one question that I will direct for you. You mentioned that investor shareholder may be able to recover its loss arising out of acts by directors that cause loss to the JV entity, and in turn the value of the investor shareholder shareholding. How does the investor shareholder circumvent the reflective loss principle that would preclude a claim for loss in the shareholding value?
Absolutely. Well, thank you to the individual who has posed this most excellent question. It is a thought-provoking question, and it is a difficult one. So gripping as it has been, that it in fact generated a decision of the UK Supreme Court last year on precisely this very topic. And first, can I just answer the question that the questioner has asked by way of an example of how one can actually get around the reflective loss principle? So, for instance, you may recall that when I was expressing my views on third-party claims, and I was giving, sorry, when I say third-party claims, what I meant was claims against third parties to the shareholder agreement, like directors, and I was expounding on the threefold classification of directors, and I talked about, obviously, examples of the types of conduct that could be committed by the non-shareholder director, which could give rise to a cause of action, one of which I focused on, which Victor also then touched on in his follow-on remarks, was on diversion of funds away from the company. And an example of which is not just plain diversion, but also the entry into of contracts which are disadvantageous and not in the best interests of the company concerned. And it may well be the case that as a result of such direct or indirect diversion of the assets of the company itself is not in a position, perhaps, or perhaps the contracting party, the entity that is a contracting party to the shareholders agreement, ultimately cannot be in a position, perhaps, to perform the obligations of the shareholders agreement, like a put option, for example, at the level of consideration that has been agreed in the shareholders agreement, or any other form of monetary obligations as a result of the unlawful acts of the non-shareholder director, so as to cause loss to the shareholder itself, and at the same time cause loss to the JV company itself, thereby giving rise, in my view, to two separate causes of action. The cause of action that is unique to the shareholder itself, the fact that he or she has now suffered loss because the reality is that there are no sufficient assets to meet the contractual put option, for example, which the shareholder is entitled to under the shareholder agreement. That cause of action and the relief, the monetary relief that shareholder can get, is the type of cause of action and the type of relief that would not be caught within the embrace of the prudential reflective loss principle, which is obviously a hallmark of common law-based legal systems. And it doesn't matter that simultaneously the company of which the badly behaved director also has a claim against the director for having breached his or her fiduciary obligations to the company itself, doesn't extinguish a personal cause of action that the shareholder may have. And the authority for the proposition, which I have just enumerated, is really the decision of the UK Supreme Court in a case which is now perhaps the leading case on the reflective loss principle, which is Sevelia and Max Financial Limited, where the Supreme Court emphasized the necessity of distinguishing between cases where claims were brought by a shareholder in respect of loss which he or she had suffered in that capacity, and cases where in the form of a diminution in share value or in distributions on the one hand, and on the other hand, cases where claims were brought, whether by a shareholder or by anyone else, in respect of loss which did not fall within that description, but where the company had a right of action in respect of substantially the same loss. In cases of the first kind, the shareholder could not bring proceedings, as it was only the company which had a cause of action. And this is our orthodox, prudential, and human reflective loss principle. However, in cases of the second kind, as where claims are brought in respect of a loss suffered in the capacity of a creditor of the company or in his capacity as a contracting party and not in his capacity as a shareholder experiencing a diminution in the value of his shareholding, there was in those circumstances no correlation between the value of the company's assets or profits and the value of the contracting party's debt, analogous to the relationship on which a shareholder based his claim for a fall in the share value, such that such claims can and should be dealt with in the ordinary way and are not extinguished by the reflective loss principle. See around paragraph 79 to 84 and 89 of the UK Supreme Court's decision in Sevalia and Marex.
Thank you, Zheng Fei, for the very precise and detailed response to that. If I know that some of you on the line may need to leave, but I wanted to perhaps just cover one more question that we've received. And Justin, I think this might be one for you. Do you think a clause for the directors to procure the majority shareholder to do a particular act is enough to bind them in arbitration? Does that mean they consented?
Well, I think that's a very good question. Thank you for whoever in the audience that raised that question. I think that's actually a point that I made when I was actually offering my own views or observations on how do we try to maximize the ability of the aggrieved shareholder to seek relief against the misbehaving directors. So I think the suggestion that I offered just now was you can potentially consider crafting the terms of the shareholder agreement to impose a positive obligation on the part of the shareholders to procure that whoever they appoint would have to comply with the shareholders agreement or the terms of the contractual documentation between the parties. So that would not necessarily give the directors basically a standing or bind them as a party to the shareholders agreement. All it does is simply to make sure there is a course of action that the aggrieved shareholder can assert against the other shareholder or shareholders in the event of any misconduct on the part of directors, for example, in terms of passing resolutions that might breach the terms of the shareholders agreement. But one way to try and bind directors to the arbitration agreement would be, for example, when you consider or when an appointing a shareholder has made an appointment, for example, and it is actually up to the board or for the company to then formalize and confirm the appointment of the directors, then you have the directors then accede to the arbitration clause only for the purposes of complying with the agreement in the shareholders agreement. That's sometimes what we see in terms of having the directors give agreement to be bound by the arbitration agreement and in the discharge of the duties as directors. So that's quite common, and that would be the most direct way of ensuring that the aggrieved shareholder would also have a course of action against the directors. I hope that addresses the question.
Denise, I'm so sorry, I know we're into overtime, but I just want to supplement something that Zheng Fei said. Not in any way to undercut what he said, but to supplement it. You mentioned the UK Supreme Court of Marex and Sevier last year, and essentially that overruled the earlier case of Johnson and Gore Wood. And in an extreme nutshell, the difference is that Johnson and Gore Wood treated reflective loss as a procedural rule, and Marex and Sevier said it's a rule of company law. Now, position in Hong Kong is that the CFA in a case called Waddington, in which I had the honour of appearing, said several years ago that Johnson and Gore Wood was the basis of reflective loss. And so the position in Hong Kong is that we still follow Johnson and Gore Wood unless and until our CFA adopts Sevier and Marex. So just a footnote that I wanted to make, but it doesn't affect the substance of what Zheng Fei said.
Thank you, Victor. Well, I think that conveniently brings us to the close of this session. So before we close this session formally, I'd like to thank every one of you who dialed into this session. I hope that you find this session and discussion that we had useful. And also a big thank you to both Victor and Zheng Fei for your helpful insights and also recommendations and suggestions on the issues that we have covered on this session. So thank you so much. And thank you all for attending.
Bye.
Bye-bye.
Bye.
Thanks very much, everyone.